Hello, everyone. I am Thomas Vick. I am the attorney at Vick Law PC, and today I want to talk to you about long-term care and applying for Medicaid while protecting assets. Um, we want to talk about the Medicaid application process and also what are some strategies that elder law attorneys use to protect as much of the assets of an individual's estate as possible. Um, and to set the stage for this discussion, um, if you've seen some of my other videos, I've made mention of the resource test for Medicaid eligibility. In order to be eligible for Medicaid for the aged and disabled or for Medicaid waiver in Indiana, an individual's um, resources cannot be above $2,000. Now, if both spouses are, if you're married and both spouses are in the nursing home or otherwise receiving services on Medicaid waiver, their resources cannot be above $3,000. Um, and then we'll talk about this in this video. There are some provisions that allow for a healthy spouse to protect more than just the $3,000 if the sick spouse is in a nursing home or on Medicaid waiver. And so $2,000 for a single person, $3,000 for a married couple when both spouses are receiving services, and then there are some extra protections for the community spouse, or otherwise known as the healthy spouse, when the sick spouse is receiving some services. So this is what we're dealing with, and there are some planning opportunities for individuals who are applying for Medicaid to preserve more than $2,000 or $3,000, as the case may be. So I want to talk to you about some of the transfers that are exempt for Medicaid purposes. Um, Medicaid is going to, when you apply for Medicaid, Medicaid is going to look back at what you have now and what you have gotten rid of in the last 5 years. And the warning is that if you have made a transfer without sound legal advice within that 5-year time period, you may be assessed a penalty period. And the penalty period is basically the number of months that you're going to have to privately pay for your own care prior to Medicaid paying for the long-term care bill. And so obviously sometimes we do want to make transfers, whether to family members or whatever the case may be, but we need to do so in a sound legal way so that we don't get a penalized transfer that we don't want. So one of the first exempt transfers is just a transfer that is for adequate consideration, basically shopping. Sometimes we clients need to just spend a little bit of money going and buying household goods so that their resource limit is below $2,000. One strategy is promissory notes. With a promissory note, an individual can loan, say, $50,000 to a child, and the child will pay back that loan to the individual for a period of time at with an interest rate, a low interest rate, and that transfer is an exempt transfer. That's perfectly acceptable in Medicaid's point of view, and no penalty will be invoked as a result of that. And so, for instance, if you have $100,000 that you want to protect, and using rough numbers here, it may be possible for us to gift $50,000 to a child, so that that amount is preserved for the family, and loan the same child $50,000, and that child will return that amount of money um, to the individual. By doing that, we have, yes, invoked a penalty period, but instead of a penalty period of about 15 months, by doing a half gift, half loan strategy, we've roughly cut it down to about 7 or 8 months that we will have to, to pay for our care. And this is, that seems high, but unfortunately, in a lot of circumstances, families find themselves with a lump sum. They may have already applied for Medicaid and been denied because they had a lot of resources, perhaps that $100,000, and they're just waiting for that $100,000 to run out before mom or dad can get on Medicaid. But by doing this gift and loan strategy, we can nearly cut that penalty period, that period where we're paying privately, in half, so that we can get on Medicaid sooner, and we have preserved a good sum of money um, for the family. Another exempt transfer is to a spouse or to a trust for the sole benefit of the spouse. The caveat with a trust for the sole benefit of the spouse is that it truly cannot be for any other person other than the spouse. It can't be for children or grandchildren. The beneficiary has to only be the spouse. Um, it's an exempt transfer, but upon death, that that trust is probably going to be paid out to the estate, and then Medicaid may have an opportunity um, to put a claim in the estate for the services that have been provided to the spouse, or to the original sick spouse. So that may or may not be an optimal situation. It just kind of depends on what the facts of the case are. Another exempt transfer is to a disabled son or daughter. Some other exempt transfers are to a trust for a disabled person under age 65. And with these exempt transfers, for instance, to this disabled person under age 65, if you have $500,000 that is sitting in a checking account, and you have a disabled person in your family, we could just draft up a special needs trust for that individual and put $500,000 in the special needs trust, and all of it will be protected, will be preserved for the disabled person, and the individual transferring that amount of money will immediately be eligible for Medicaid. Another exempt transfer are transfers that are beyond the 5-year look-back period. So when we do the Medicaid Asset Protection Trust, the 5-year look-back period, we hope that we reach the 5 years, and after that 5 years is complete, everything in that trust is protected. And then let's say we don't make it 5 years, but we had a transfer that was not an otherwise exempt transfer. If we can get that asset back into the individual's hands, then you will not be penalized for the exempt transfer. So, for instance, if an individual gave away $20,000 to a son, or to a son 3 years ago, Medicaid's going to look at that transfer and say that is not an exempt transfer, and we're going to have to assess you a penalty, and you're probably going to have to pay for your care for about 3 months. But if we can get that $20,000 back into the parent's hands, then you will not be assessed a penalty. And so that's also a strategy for us. And in the situation when a healthy spouse is at home and living there perfectly fine, and then we have a sick spouse that may be receiving Medicaid waiver services, which can be in the home or is in a nursing home, we're not limited to that $3,000 of a resource limit. We can have more than $3,000 based upon these special resource rules. And essentially what that means is from the get-go, you can have protection of about 50% of the couple's property. It starts at $49,400 or less. You get to keep, the healthy spouse gets to keep $24,000. If you're in between $49,000 and $235,000, then the healthy spouse gets to keep 50% of that. And then if you have over $247,000 between the two spouses, then you get to keep $123,000 for the healthy spouse. And that's really the floor. There are other strategies that we can use. For instance, with the sole benefit, the trust for the sole benefit of the spouse, promissory notes, gifting strategies. Those things are still possible with the $123,600 limit for a spouse, really with all of these limits with special resource rules. And so it gives you an additional floor, a higher floor to start from to do Medicaid planning when there's a healthy spouse and a sick spouse. And so there is a wide range of possibilities when it comes to preserving assets, even when we're in a situation where money is being drained due to the cost of long-term care. And so I just wanted to provide some options out there for people so that you know, and you can begin thinking about what would be the best choice for your family. And so special resource rules are possible. Exempt transfers are some of the planning opportunities available. I also want to take a moment here to let you know that if you're interested, you can receive a detailed written evaluation. If you schedule a consultation with us, I will be happy to meet with anybody that is in a similar situation, whether you're wanting to prepare for long-term care or whether you're in a long-term care crisis right now and you find yourself draining the funds. A consultation with an elder law attorney is very much advisable. So go ahead and schedule your consultation. We'll get you a questionnaire to fill out. You'll fill out the questionnaire and meet with me, and then you'll have an opportunity to receive an evaluation after the consultation. So feel free to get in touch with me. The website is viclaw.org. Email is thomas@thomasviclaw.org, and my phone number is 317-884-3133.